like to call this meeting to order. Thank you for joining us during our weekly hybrid MLS breakfast meetings. My name is Tom Zeng, and I'm your February program chair. A little bit about myself. I'm a broker associate at Universal Elite Realty. I've been practicing real estate full-time for 14 years, and my experience in real estate includes standard sale, short sale, REO, flipping, multifamily, and I'm now slowly shifting my business towards warehouse buying, leasing, and some commercial retail spaces. I've been serving as director at WSGVR since 2022 and was a former CAR director. Some of my designations include GRI, CIPS, and At Home with Diversity. I'm currently working towards earning my CCIM designation at this time. It's my honor to be your February program chair. Now, help me welcome our guest speaker and a close friend of our association, attorney Jim Klinkert. Jim Klinkert is a lead trial counsel for Klinkert, Gutierrez, and Neville. A veteran of many dozens of trials, Jim has tried cases in various state and federal forums involving such diverse areas of law as public and private construction, employment, title, contracts, escrow, business interference, partner and shareholder disputes, broker liability, professional malpractice, lender liability, commercial transactions, estates, elder abuse, broker and contractor license revocation proceedings, wrongful death, and major personal injury. Jim graduated with honors from Loyola Law Schools in 1984 and began practicing law the same year. A former real estate broker, Jim has been active in organized real estate for more than 2 decades as an advisor to local realtor associations and a member of the California Association of Realtors Legal Affairs Forum. Outside the courtroom, Jim is an accomplished classical pianist. Let's welcome Jim.
Basically decided we would focus on 3 areas this morning. There's California's new law regarding buyer representation agreements. It sort of extends from the antitrust settlement practice changes. And then I want to talk for a few minutes about some of the new residential tenant and borrower protections that are in California, went into effect last month. And then I also want to spend some time talking about the developments related to the January wildfires. Try to be shorter next time I visit you. The microphone will work better. That's right. Next slide, please. So those are the 3 areas I mentioned I wanted to focus on this morning. Next slide, please. So as you're all aware, last year, a large antitrust lawsuit against National Association of Realtors and various members of NAR was settled. And as part of that settlement, certain changes to the way we all practice real estate were mandated. And one of those changes had to do with the requirement that somebody representing a buyer had to have a written agreement with that buyer. So that's the background. That went into effect last fall. Effective January of this year, California has kind of added on to that and changed things a bit. In California, there is now a law, AB, basically, there we go, AB 2992. And that requires also that a broker or an agent representing a buyer have a written agreement with that person. Now, it's a little bit different than the antitrust settlement requirement. The antitrust settlement requirement only applied to residential brokers and agents who are members of the National Association of Realtors and MLS services. And it didn't apply to commercial, industrial, or empty land or anything like that. The California law goes beyond that. It applies to all kinds of property, commercial, industrial, vacant land, units that are more than 4 units, residential, anything like that. And it applies not only to members of NAR, realtors like all of you, but it applies also to any licensee. So you could have a license, not belong to NAR. You're not necessarily subject to the antitrust practice changes, but you are subject to AB 2992. There's a little bit of a difference in how AB 2992 works compared to the antitrust settlement changes. Under the antitrust settlement, you were required to have an agreement with a buyer before touring a property. Under AB 2992 in California, it's not quite that clear. It's as soon as practicable, whatever that means. That's sort of an invitation to litigation, which I guess is good for me, but we don't know exactly what that means. But we know there's a bright line. No, certainly no later than the time the buyer signs a purchase agreement or an offer to purchase. Next slide, please. The agreement, I'm sure most of you have worked with the buyer representation agreements that are one of the car form library. The agreement has to contain an itemization of what compensation the buyer is going to pay the buyer's agent, what services will be rendered by the agent, when the compensation is due, when the agreement terminates, and a statement that the compensation is negotiable. Next slide, please. There are limitations on the term of the agreement. Under California law in AB 2992, a buyer representation agreement cannot be for longer than 3 months. It can be renewed for an additional 3 months, and there is an exception to that rule. Buyers who are corporations, LLCs, or partnerships are not limited to 3-month terms. The agreement can't have any automatic renewals. It can't have a provision in there that says that unless either party notifies the other party, the agreement rolls over for another period of time. That's not allowed. And any renewal has to be in writing and signed by both the agent and the buyer. Next slide, please. The antitrust practice changes that went into effect last year are still in effect. So there's kind of an overlap. You're basically subject to whichever has the more stringent requirement. As an example I've got in my slide, if you're working with a residential 1 to 4 unit buyer, the buyer representation agreement has to be signed before a property is toured, even though AB 2992 wouldn't necessarily require it until an offer has been written. Next slide, please. The Department of Real Estate is going to be promulgating regulations that explain and interpret and implement AB 2992. They're in the works now. I would imagine we'll probably see a draft of them sometime, maybe by late spring or summer, and I would expect them to be in effect by the fall. I was talking to Assistant Commissioner Steve Lerner recently, and some of the things I expect they're going to be in those regulations are a definition of what 3 months means. 3 months is kind of a nebulous term because it's always confusing. Some months have 31 days, some have 30, some have 28. The definition of 3 months is likely going to be defined as being 90 days, which is more clear cut. There's a question of, in an open house situation, of whether or not an agent represents a buyer that first walks in the door. That's kind of an open area. And I think this regulation is going to lay a somewhat clear line that at the beginning of an open house, at least, somebody who walks in is not an agent. The agent who's handling the open house is the agent of the seller at the outset. And just because a potential buyer walks in, that doesn't immediately trigger the application of this law. But that can change. If at an open house, somebody walks in, you as the seller's agent, as a listing agent, don't represent them yet. But if you start talking with them and agreeing you're going to work with them and show them property and help them find something, then all of a sudden AB 2992 and the requirement of a written agreement does come into effect. I expect the regulation also to make it clear that just referring somebody to an open house is not or referring them to a website is not the showing of a property. So let's move on next. There's a series of laws that went into effect mainly in January, but a few of them a little bit later this year, having to do with protections for tenants. And one of the chief ones is a limitation on tenant screening and application fees. Basically, this law says, as a general rule, a property owner can't collect tenant application and screening fees from a prospective tenant. Now, that's subject to a fairly big exception. A property owner or a landlord can do that if the landlord adopts a real clear set of guidelines as to what they require of a tenant. And then you have to have a policy that does one of two things. Either the policy has to provide that you as an owner will review all applications in the order they're received, and that you will except the first tenant that meets the guidelines. An alternate to that is that screening fees can have to be refunded to all applicants not selected by the property owner within 7 days of tenant selection or 30 days after application. My understanding is that most major landlords are doing the first one. They're adopting a policy that says we're going to collect applications, and the very first one, we're going to review them on a first come, first served basis as they come in. And the first tenant who meets our criteria is going to be approved. And that seems to be the safest and easiest way to go. Another aspect of landlord tenant law that has changed in January is that move in and move out and repair cleaning photos are now required. A prudent property owner, even without this law, will implement a policy of documenting everything they do. If they'll document the condition of the property before a tenancy begins, they'll document it after the tenancy ends, and they'll document any conditions and any repairs that are required. This law makes it mandatory that that be done. And basically you've got to it's good because there's an awful lot of litigation over deposits. I've got several in my office right now, mainly with commercial properties, but having to do with property owner claims that wear and tear was excessive and that a tenant or a departing tenant is responsible, sometimes for some pretty big ticket items. So this hopefully will cut down on some of that. You have to take photos within a reasonable time after a tenant returns possession, but before any repairs or cleaning are done. That portion of the law becomes effective on April 1st. You have to take photos immediately before the beginning of a tenancy. And I'm not sure why there's a different triggering date, but that requirement doesn't go into effect until July 1st. And then all of those photos must be provided if the landlord is going to charge anything against the security deposit. You've got to provide the photos to the tenant so they see all your documentation of why you're doing what you're doing up front. You have to have an explanation for any cleaning charges or repairs or anything like that that's being done. The way you deliver that, there's several options. You can snail mail the photos you took to the tenant. You can email them. You can provide a link to a Google document or something like that, or you can provide them on a flash drive. And the law clarifies kind of what existing law has been right along. Only repairs that are reasonably necessary to return the premises to pre-tenancy condition, reasonable wear and tear accepted, are allowed. That's been the law, but this codifies it, clarifies it, and that's AB 2801. Another new protection for tenants that it goes into effect basically April 1 is a requirement that you notify tenants that they have the right to request positive credit reporting. So that's effective for leases existing on April 1 or entered into on or after April 1. And CAR has published a form for this. The landlord has to make an offer to the tenant of positive rental payment information to at least one consumer reporting agency. And you must make that offer to a tenant at least annually. So every year you've got to renew that offer. The CAR form that's been developed is TRPR. That was basically went into effect on December of 24. Tenant fees and security deposits SB 611, a landlord can no longer charge for processing personal checks or charge for legal notices like a 3-day notice to pay rent or quit. Another aspect of SB 611 is that any higher deposit that has been charged to a military member can only be kept for 6 months. After 6 months, it has to be returned to the tenant. Next slide, please. There are a few other new tenant protections I've kind of lumped together in this screen. As you know, for the last few years now, there's been a law on the books that a tenant who is the subject of domestic violence can require that locks be changed and the landlord do certain things to protect that tenant. SB 1051, effective in January, clarifies that the landlord is the one who has to pay for any lock changes necessitated by domestic violence. There's been a change in the procedure for evicting a tenant who isn't paying the rent. AB 2347 changes the amount of time that a tenant has to file a response to an unlawful detainer complaint from 5 days to 10 days. AB 2898, effective in January, has to do with parking in multi-tenant facilities. I guess there's been a problem in some situations with property owners charging for parking as part and treating that as part of the obligations of the tenant to stay in their place. AB 2898 says all that has to be unbundled, at least as for new developments. You can't have parking fees tied to the regular rent for the premises. You have to have a separate contract. And significantly, if the tenant doesn't pay its charges for parking, you can't evict the tenant based on that. You can just cut off their rights to park. And then AB 2579 has to do with balcony inspection deadlines. You'll probably remember for the last several years, there has been a law on the books mandating balcony inspections for multi-unit facilities and condos. And that can has been kicked down the road from year to year over the last few years as to when the effective date is. And it's been extended now to January of 2026 for rentals, but not for condo projects. So if you're involved in managing a condominium project, keep in mind that that law requiring inspections had to be complied with by January of this year. Next slide, please. There's an important new law having to do with foreclosure sale date extensions. And this is kind of a big deal if you are ever working with people who are faced with the possibility of foreclosure. As you know, traditionally, it takes approximately 4 months to complete a non-judicial foreclosure. You've got to give a 90-day notice of default that has to be recorded and served. And then beyond that, you have to notice the trustee sale date. That requires at least another 20 days, sometimes a bit more, to cut off tax and local liens. But that's altogether, it can be done in as short as about 4 months' time. And it's always been a challenge to try and stop a foreclosure. If you're getting close to the date, we get calls periodically from people. They don't usually call the day they go into default when there's some time on their hands. They'll call when the trustee sale is scheduled the following week or something. And it's possible to get into court and stop one of those sales, but it's kind of an iffy proposition. You got to get a sympathetic judge. You got to jump through a bunch of hoops to get an injunction against a foreclosure sale. And it may not be granted. And then even if the court decides that, yeah, there's good reason to halt the sale and give the borrower more time, the court has to impose an injunction bond, which is very, very difficult for a borrower to get. They generally have to be cash collateralized, so they're not readily available. What AB 2424 does, it provides a couple of really generous safe harbors. It says, first of all, that if you have the property listed at least 5 days before the sale date with a licensed broker on an MLS, so it's a legitimate bona fide listing that's going to get exposure, the trustee has to extend any pending trustee sale date by 45 days. That buys quite a bit of time to get a property marketed and potentially sold. And then beyond that, assuming that a buyer's found, you get an additional 45-day extension if the trustee is notified of a bona fide executed purchase agreement with a sale price at least equal to the unpaid balance of all obligations secured by the property. That's probably going to be one of the rubs there. I think in a lot of situations where there's a foreclosure, you may not end up with an offer from a buyer to cover that plus any other obligations on the property. Next, let's talk for a few minutes about the wildfire situation. And you've all heard a lot about price gouging because we've been bombarded with notices and warnings and information about that. And it's kind of a tricky area of the law because it's hard to know how it's going to be interpreted and how it applies in certain situations. California's anti-price gouging law has been on the books for several years. It's Penal Code Section 396. And basically, Penal Code Section 396 provides that whenever there is a declared state of emergency, somebody can't advertise, offer, or charge prices that exceed more than 10% beyond what the prices were before the declared emergency. And that applies not only to housing, but to food, gas, medical supplies, just about any products. And the law activates whenever the US president or the California governor or a local authority declares a state of emergency. And the state of emergency is typically the duration of the application of the anti-price gouging law typically lasts for 30 days after the emergency is declared, but it can be extended. And that's what's going on in California now as a result of, we've actually had 2 declared states of emergency. We had a declared state of emergency having to do with the bird flu. Now, I'm not exactly sure what the timing of that is right now, but then back in January as a result of the wildfires, both up in Eaton Canyon and out in the Malibu area. Next slide, please. This is a big deal. And it applies not only to property owners, but also to agents and anybody involved in the process of providing rental housing. The penalties are severe. You can be criminally prosecuted and actually face jail time for this. You can be fined, and I think the fine is like $10,000 or something. And it probably most importantly for all of you, you can lose your real estate license if you violate the law. There's a provision of the Business and Professions Code that essentially makes any violation of California law a possible ground for suspension or revocation of your real estate license. Next slide, please. Housing means any rental housing with an initial term of no longer than 1 year. That's the way the law is written, but Governor Newsom has already issued an executive order eliminating that loophole. Because I understand property owners were trying to get around the anti-price gouging law by writing rental agreements or leases for 366 days, in which case it would no longer be subject to the 10% limitation. So Governor Newsom issued an order, scrapped all of that. So even a longer term lease or rental agreement is still subject to the 10% limitation. The law applies to mobile home spaces as well. How it works kind of depends on the situation you're in. For existing rentals, you can increase by no more than 10% compared to the pre-emergency levels. That's pretty easy because with an existing rental, you know what the rents were right before the emergency was declared. It's a little bit more complicated when you have a situation when a property has not been rented at the time the emergency is declared. If a property is not currently rented, but has been rented or offered for rent within the preceding year of the state of emergency, rent can't be increased by more than 10% beyond the most recent price offered before the emergency was declared. And then it's much more complicated and convoluted if you have a new rental. So if you've just purchased a property and you're going to place it into the rental pool for the first time, then you got to figure out it can't exceed 160% of the HUD fair market rents for the area. And there's no real clear way of determining that. There are tables I understand online, which I haven't looked at and don't know exactly how they work. Some of you may have had experience with them, but you've basically got to do a little bit of digging and research to figure out what the maximum is you can charge without running afoul of the anti-price gouging law. So you figure out where the property is, and then you go into these tables and figure out what the HUD fair market rents for the area are, multiply that by 160%, and that's your safe zone. There's one additional kicker. If a rental unit was previously unfurnished, but now you're offering it on a fully furnished basis, you can add an additional 5% to the allowable rent limits. It gets even murkier in the application. For example, you got the LA County wildfires. Well, the anti-price gouging law may not apply just to LA County or Ventura County. It may apply also to surrounding areas that are impacted. For example, if you've got quite a few, hundreds of people who have been displaced, for example, up in the Altadena area, some of those people may look for rental housing in North Orange County, perhaps, or possibly West San Bernardino County. So those areas may also be subject to the anti-price gouging limitations. So it can apply to different zip codes. It may involve different deadlines. There are some exemptions. Governor Newsom, in another executive order, issued an exemption providing for single-family homes that have 4 or more bedrooms and a fair market rent of at least $5,500 a month in certain zip codes may be outside the scope of it. And what I understand, I haven't read all these and I don't stay on top of them. I think there's a list, there's a pretty good set of resources on the CAR website that basically updates all these things regularly. My understanding is that Governor Newsom's been issuing executive orders on just about a daily basis since this all began. And it's not just the state of California. There may also be local emergency orders in effect that you have to be mindful of. Next slide, please. That's it. Well, just a few other things. The protections of the law can't be waived. And this is important if you're out in the industry. The law applies to unsolicited offers. So even though you don't think you're violating the law, you're not out there listing property or offering it for rent at an amount that's greater than 10% of its previous rental amounts. You can still have a problem if somebody comes to you with an unsolicited offer. So if you've got rental property and you're subject to this law because of the pending emergency, and the offer seems like it's in an amount that exceeds that 10%, be really, really careful, because you can end up in the soup on the whole thing, even though you didn't initiate the contact. So anyway, there is a wealth of information on this on the CAR website, and I would encourage you to go look at that if you have questions or want more information. And I got a few minutes left. I think if there are any questions, I'd be happy to discuss them with you.
Just going to get us started for AB 2992. Does the law applies to commercial buyers too, or only residential?
AB 2992 applies to all kinds of property. Raw land, commercial, industrial. It does not apply to rentals, like leases and stuff. That's outside the scope of it. But any property that's purchased of any sort. But Buck's going to have to ask the hard question.
No, Jim, thank you for the presentation. Hopefully we can access your slides. In rent control, City of Los Angeles, a tenant that's been there for 20 years, paying $500 a month rent in a unit that fair market value on the low end is $2,000. When she moves out, are we going to be in violation of that 10%, only being able to raise it to $550?
Yeah, probably. If that, I mean, the 10% limitation is based on the pre-emergency level that it was rented at. I think that it would be a different situation if it was new rental unit coming online and it hadn't previously been rented. But in your scenario, it's been rented below market. So I think we're stuck with that to avoid the application of the anti-price gouging law. Of course, that has a short duration, hopefully 30 days or not too much longer than that. And then you'd be back into the normal rent stabilization ordinance in LA and what that allows.
Good morning, Jim. I got a couple questions. One is when you say that we need to return the tenant's application fee and credit check fee.
Yes.
What if we're using the rent spree, which we don't touch any of that fee? We hook up to rent spree, send him an email, had him to sign up, and then they pay the company.
So you're using a third-party vendor basically to do your
Yes.
screening. I haven't considered that, but I don't think the law applies. That would be between the tenant and that service, I think. And now, if are any portion of those fees turned over to the property owner by the service?
I don't even know how much they charge. Yeah.
I'm not 100% sure. That's a good question, but I don't think it would be an issue.
Okay. Thanks. I'll find
Sure.
out. Too. Also, the second question is, all these changes, does it apply if the tenant have animals? If now with the wildfire and stuff, now they need to bring in animals and stuff. How's that change?
The anti-price gouging stuff with the wildfires, I don't think has any bearing on animals and what have you. The whole issue of pets and protections for people that have need for service animals and comfort animals and that kind of thing, that's kind of a complicated area. I don't think it bears direct. I don't think it's affected by the emergency situation or these new laws that I've been talking about.
Okay, thank you.
Thank you.
Jim, it's me again. I've got two questions for our Zoom friends. First one's from Eric Hayashi. Is the credit reporting required for tenants on month-to-month agreements?
Does the property owner have to get credit reporting? No, that's up to the property owner if they want. But if they are taking in screening fees and what have you in connection with an application, then you're subject to limits we talked about.
The second question is from Marcio Rudar. If you rent your home to a fire victim, will you lose your Prop 13 exemption?
I'm sorry, will you lose what?
If you rent your home to a fire victim, will you lose your Prop 13 exemption?
Don't know if there has been any action taken to, I mean, I have, that,
It's okay. Thank you.
I don't know how that would, I don't think so, but yeah. Well, the Prop 13, you mean the property tax limitations and what have you, if you're,
Yeah, Prop 13 exemption. Yeah.
I don't know. I would need to look at that before I ventured in any kind of a guess. That's a good question though.
Thank you, Jim.
Thank you.
Last question.
Thank you. I have a question. So, what is the landlord's right when tenant is not paying for the late fee, and the late fee has a clearly stated into the lease agreement?
I mean, that's a breach of the lease, which could lead to an eviction. As
So
to,
that could be the reason.
it could be. I think a lot of property owners and eviction lawyers are cautious about basing evictions just on that. That's kind of tenuous.
It's not
but-
strong reason.
It's, yeah, also, there's an overlay if you're in LA County, which I imagine most of the transactions you'd be talking about are, I don't know how the rent stabilization ordinance affects that off the top of my head. There may be limitations on what you can do in terms of evicting somebody just for failure to pay late payments.
Thank you.
Okay, sure. Thank you. Thank all of you. Good to see you.
On behalf of West and Gabriel Valley Realtors, I would like to thank our guest speaker for a very informative and knowledgeable presentation, and we have a very small token of appreciation for you. Please join us next week as we welcome an affiliate panel. Their topic will be disaster aftermath. Thank you, everyone, for joining our weekly meeting today. Have a wonderful day, and this meeting is now adjourned.